Thank you to everybody for joining us for the Best Practices Regarding Technology webinar. I'm going to be your moderator, Tim Anzenberger. I'm a partner at Adams and Reese. And this webinar is a part of the Financial Poise series on legal ethics best practices. You can turn to slides 6 through 10 to get a summary of the series and also this episode specifically. Now, speaking of those slides, we are not going to go through those in order. And you're also not going to have to listen to us read slides to you. This is not a PowerPoint presentation. Instead, this webinar, like all Financial Poise webinars, is a conversation. And I'm looking forward to talking with our panel about ethics and technology, which, as we all know, is a scorching hot topic currently. But you will want to keep those slides handy, because as we go, I'll indicate which slides we are addressing just as a helpful reference as we carry the conversation along. Now, for our panelists, the stars of the hour, joining me today are Stephen J. Conover of Carmody, Torrance, Sendek, and Hennessy, LLP, Michael Downey with the Downey Law Group, LLC, and Jonathan Friedland of Much Shellis, PC. Now, we know that you're attending this webinar to learn about ethics and not to hear infomercials about us. So if you're inclined to read more about us, you can see slides 69 through 73. Also, a big thank you to our co-producer, which is the National Law Review. And again, this webinar is a production of Financial Poise, and you can sign up for our free weekly newsletter if you go to financialpoise.com/subscribe. If you're attending this webinar live, you can submit questions using the web portal. And if you're watching on demand or you have questions after the webinar is over, you can submit those by email to info@financialpoise.com. Just include your question and the name of this specific webinar, and we'll do our best to get you an answer as soon as we can. And with all of that, let's go ahead and get started. Now, technology has long been a part of the practice of law, even though many, if not most, lawyers wish that it weren't. And while that's always been true, the rapid advancement of technology during and now after COVID-19 has made issues associated with technology all the more important and prevalent, as we had a huge number of lawyers and employees of other firms working from home, working remotely, still to this day, and using technology to get that work done. So there are a lot of areas to address when it comes to legal ethics and technology. And so we might just be getting into the tip of the iceberg on this webinar. But our hope is that we're going to give you some key tools, key citations, and examples to help you learn as much as possible and give you some reference points moving forward. So with that, Stephen, let's start with you and the basics. The model rules of professional conduct, which have been adopted by most, if not all states in some form or the other, actually already include provisions that address a lawyer's knowledge and use of technology. Can you get us started today with sort of an overview on those fundamental principles and fundamental rules?
Well, thanks very much, Tim. Absolutely. The model rules of professional conduct as they relate to technology start with Rule 1.1, which is entitled competence. The basic competence that lawyers are intended or required to have exceeds just the knowledge of the law. They need to understand the existence, relevancy, and use of technology. That's where it starts. It also spills over into the other rules where the lawyer is intended to represent clients and actually fulfill the obligations that the clients are hiring the lawyer to perform. Confidentiality under Rule 1.6, and methods and means of communications governed by 1.4. If you're not recognizing the obligations of technology, the risks and benefits of the technological opportunities available, you cannot fulfill, or it's more difficult to fulfill those obligations under Rule 1.4 of communication, effective communication, and Rule 1.6 governing the confidentiality of those communications. Now, there was a time where things blossomed and technology was moving at a relatively lethargic pace, and lawyers could get away with knowing the law and to the exclusion of everything else. Those Luddites would say, well, geez, I don't know how to work that machine, or I didn't know how that software worked. That's a thing in the past, because if you say that, you're creating liability risk and ethics risk. The rule doesn't require that you understand how electricity works, but you do need to understand when you flip the switch on the wall that the light is going to light above you or in that room. You don't have to know, a lawyer doesn't have to know how the internal combustion engine works, but if you get behind the wheel of a car, you do need to know the rules of the road and the operation of that vehicle. So with that, those clients who are using software or using technology to communicate, to deliver information, to deliver documents and other data, as well as delivering money, lawyers need to be aware of the benefits and significantly the risks presented by the client's use in means of communication and fulfilling their obligations to the lawyers. So those are the foundational components that enable us to integrate the use of and access to technology in the practice of law day to day, not only in representing the clients, but operating the law firm itself.
And when I'm looking at just these basic roles, I tend to think of the lawyers that say, I had a partner once who's now retired who didn't want to do legal research on the internet. He only wanted to use books. And you hear lawyers now say, I don't need to learn about AI. And then you look to rule 1.1 at the very beginning where, well, actually, you need to know how to use that and how to appreciate that as part of, one of our core duties as a lawyer.
Years ago, I don't want to date myself, but there were lawyers who said, "Well, geez, I don't want to go on Facebook. I don't need to understand Facebook." Yes, you do, if you're going to recognize the risks that clients are creating for themselves in your representation of those particular clients and trying to preserve the confidentiality that goes along with the representation. So understanding it and using it may be two different things, but recognizing that there are benefits and risks is the core component of the competency obligation imposed by Rule 1.1.
If I may just point out another example that comes to my mind as Stephen, as you were talking. So yeah, if a lawyer doesn't use Facebook, if I choose never to use Facebook, I guess I have no obligation to understand it for myself. But here's an example of what if I read a negative Yelp review? Not that I practice the kind of law where I get Yelp reviews, but let's say I did. If I choose to respond to that, I've got a real problem depending on how I respond. So it comes up, whether you're talking about, how you do legal research. I mean, it's just very, very wide ranging the way technology impacts our practices.
And looking at one of these other rules, confidentiality is obviously one of the, most basic protections and ethical rules that we think about when we think about, attorney-client privilege and even the larger idea of just what confidential information is to a client, which I think leads into data protection, the client's data, the client's confidences that we keep now on hard drives. And we all know that data protection is absolutely critical, not just from outsiders, obviously people trying to infiltrate your firm's systems from the outside, but from insiders as well. And Michael, I'll direct this to you. There was a relatively recent example of how this played out where a big law firm had its COO, who was a non-lawyer, leave the firm for a competing firm. And before he left, took with him, he downloaded off the system 34 gigabytes of confidential information. It included information about the firm and its partners, but also the clients. And the allegation was that he was taking that to use at his new firm. Can you talk about the issues involved there and the larger implications of this, data protection issue?
Sure, and this really strikes upon an issue that goes beyond the rules. When we talk about protecting data, certainly Rule 1.6C of the model rules does have a provision that relates to taking reasonable precautions to protect information. And this particular instance involved intentional taking of data. There are other instances where, frankly, it's just a lack of protection. And the rule, I think, does a nice job of trying to address that. But warning lawyers, you can have people deliberately try to take your data, both insiders and outsiders. And you also can just have those inadvertent examples. And so you need to be thinking about how how do we handle information? Where does it go? How is it transferred? And making sure you're taking precautions at each of those stages. The other thing I think that and the case you were talking about actually involved Proskauer Rose, a top, very good, very well respected New York based firm, an international firm. And it really sort of a reminder that these types of problems can arise really at any law office. But I think it's a reminder to people that you need to have the technology protections in place. You also need to have things like user controls. Did that chief operating officer need access to all the information he got access to? And then the third area of things is making sure that you also have in place proper agreements to protect information. That may be agreements with the technology providers, or in this case, with the employees. Often in my work, I find that law firms haven't entered employment agreements with people. They may not have an operating partnership or operating agreement with their partners. It's really critical to have the good documentation that you would encourage your own clients to have to make sure that if something, if someone is leaving, they know they can't just take firm information, and to make sure that they're not able to access information they may not need for their work. We lawyers like to have everything available to everyone, and that creates a lot of risk when some sort of problem does arise.
I think lately, especially the past couple of years, we've seen an environment where lawyers are leaving for other firms. Constantly we see groups getting picked up by other larger firms. It's January, so I'm sure everybody's seen on LinkedIn and the legal publications all of the movement from lawyers intermingling and moving to different firms, especially right now. So Jonathan, this is directed to you. With more and more lawyers leaving firms and going to new firms, what do law firms need to know about protecting sort of their own confidential information? These could be forms, these could be CLE materials. I think of what I normally think of as what people consider to be forms that are actually just draft pleadings that were drafted for clients in matters that people think are forms, but might be actual client protected. It might be client property or firm property. What do law firms and lawyers need to know about that aspect?
So, in a fundamental way, slides 30 and 31 cover the question. If we take a step back, though, and we start with, at least I start with, the concept of, the public policy that, the client has the right to choose a lawyer. And the law firm can protect things like trade secrets, but the law firm can't protect other things that could get in the way of a lawyer doing her or his job, broadly stated. The court decisions, they delineate between, documents related to professional practice, memos, forms, pleadings, and internal firm operations, billing data, realization data, strategic plans. And I think that for a firm to try to restrict the taking of the sorts of things that allow a lawyer to do their job doesn't really, is antithetical to the general policy of, client choice.
Following up on that, Jonathan, but the law firms need to identify and publish boundaries so that the different levels of people working at the firm, assistants, receptionists, paralegals, lawyers, non-lawyers, so that they understand the distinctions between the documents and the data that the firm has that are available to each of them for the performance of their job, as distinct from the information that's necessary to operate the law firm itself, referral sources, vendor contracts, as you mentioned, realization. But without publishing it, without identifying those boundaries, it makes it more difficult to implement this obligation to have reasonable policies to preserve the confidentiality and protect the client, the data that we have in law firms for clients.
Without a doubt, and to sort of layer on top of that, I mean, let's say a firm has no policy whatsoever, that doesn't obviate, ethical rules every lawyer's bound by. It doesn't obviate, fiduciary duties, but both in terms of, the question is, the broader question I think you're putting forth is, is the reasonable measure standard satisfied? And that's more of a question to I believe, to maintain trade secret status. Firms gotta take reasonable measures to keep the information, secret in the first place. But without a doubt, best practice, better practice is exactly as you described.
Yeah, and Stephen, these issues, with protecting the data, and then, you brought up the employees, even the secretary, the receptionist, these issues sort of dovetail into just general employment law and what firms need to be doing on a human resources standpoint. Can you talk about the implications with this into just employment law generally?
Certainly. There's a I can't say annually, I think it's every other year, that the insurance industry conducts surveys of lawyers and claims and claim losses and the payments made by insurers by people, not just clients and former clients, against law firms. And a significant component of that survey reveals that there's I consider it a large return, which is 10 to 12% regularly are claims resulting from what they describe as rogue employees. No one wants to have a rogue employee working at their firm. You need to undertake the obligation to recognize the risks, both from a liability standpoint as well as from an ethics standpoint. We as lawyers aren't required under the rules to ensure that everyone every day in every instance complies with every rule. But you do have to have a policy that enables the law firm to operate relatively smoothly with the expectation and understanding that everyone is going to comply with not only the law, but the rules that govern lawyers' conduct, as well as the methods by which we can facilitate the representation of the clients. So, yes, we need to understand that lawyers arrive laterally. They arrive out of law school and it's a startup. But at the same time, we have to recognize that the partners and associates are going to depart at some point. And we don't want them in a situation where they don't understand the boundaries of what is client-based that they would need to take with them out, walking out the door with a particular client or client matter. So publishing those boundaries ensures that there's going to be a sensitivity and understanding to prevent rogue, or at least deter rogue employees from doing it, and also ensure that the management of the law firm doesn't encounter any ethics liability from a negligent employee, negligent associate, or negligent partner who inadvertently takes or discloses inadvertently information dealing with the operation of the firm or the representation of a particular client in their departure.
And continuing along the employment law side of things, and Michael, I'll throw this to you, but with more attorneys working remotely, still even today, I know a lot of firms have in the office policies, some are coming back, but I mean, there are still a large amount of lawyers that are still working from home. And some firms, and this could be law firms or any business, have employed software and technology programs that can track and even record their employees and their lawyers. A lot of folks might be surprised or shocked to know that this software even exists that can track what you're typing, and that can even use your webcam to monitor and watch you. And there are some employers out there that are utilizing this sort of equipment. So, Michael, what do lawyers need to be thinking of when it comes to ethics and this sort of technology being employed?
Sure. So the first and obvious set of issues just relates to privacy of people. That, you may be in your employee's home, you may be able to turn on a camera for them, they may be doing, God knows what, and suddenly you're recording it. And I see you're looking at slides 33 and 34 talking about employee surveillance. So certainly there's just those types of concerns. The interesting set of issues that arises for lawyers as well is really twofold. The first is making sure the information is protected as confidential, because of course, if you're recording your lawyers working or communicating and then it's being stored on an offsite storage system operated by a vendor, you need to be worried about, okay, who has access to that information, how protected is it, things like that. The other thing, of course, is that often in disputes, lawyers will be challenged as to what work they were doing, how they were billing, and those types of things. And you've now created this, first of all, probably massive set of data, but the client's going to be able to come back and really challenge, was that really 0.3 spent on this? Was it really 0.5 spent on that? And challenge what sort of work was done and who it was being done. So I think firms really need to be thoughtful about when they're going to employ these things. And I will say, I do think that often the most important asset for law firms is their employees, and creating this system where the employer feels the need to really supervise people that way, maybe sending a message you don't want to send of really not valuing your employees and their independence. It's certainly worth thinking, is this a culture that we want in our firm, or would we rather work on a higher level of trust and avoid creating some of those records?
And when it comes to recordings, another issue related to that is especially with the new AI software, new programs. There's a lot of software and AI programs that you can use to record phone calls. You can use to record Zoom meetings, team meetings, and the technology can even take what's said during those calls and video meetings and summarize it for you into notes or outlines and save it later. And there are folks out there that are using it to record just their phone calls with clients because they might want to know, I don't have to take notes now because this AI software is going to do it for me, and then I'll always have something to come back to. They might be recording calls with opposing counsel. They might even be, despite it being outlawed by most courts, they might want to record court hearings that are done by Zoom or over the phone and things like that. And I think there's even been some new ethical rules or opinions out there on this. Michael, what implications does that kind of software pose for folks?
Sure. So the first thing to realize is there's just an initial question of, are you allowed to record the phone call? And most jurisdictions in the United States break down into two categories. One of them is what's called a one-party consent state. You may remember back in the day that when the Monica Lewinsky scandal was going, one of the things that was happening there was they were arguing, was a phone call being made, I think, from Maryland, which was a all-party consent state, or was it being made from Virginia, which I think at that point may have been a one-party consent state? The issue is if I'm participating in a phone call, am I allowed to record that call? If it's a one-party state like my home state of Missouri, the answer is yes. In a state like Illinois, where I also practice, the answer is no. You have to actually have consent of all the parties to the call in order to be able to record it. Then you step down and say, okay, is there a special concern with regard to recording, for example, client calls? Some jurisdictions actually have ethics rules or ethics opinions that say that a lawyer needs to get consent as to recording employee client calls in general. The interesting thing you referenced, there's a new New York City bar opinion 2025-06, that looks specifically at this issue with regard to using technology. And what it really comes back with, and it's a very good analysis, but it says if you're going to be recording and transcribing matters, calls related to matters, there's sort of two sets of things that need to go on. The first is the question of you need to think through the strategic implications of it. Because again, we're creating transcripts, we're creating recordings that may be discoverable, that may be able to be used in proceedings. You need to think about that. but they also were concerned about recording of clients. And I mentioned some jurisdictions. I know Missouri, for example, says you're not allowed to record any client communication without the client's permission. This sort of then falls back and says, with regard to this software, that you do need to think about, do you need client consent? And the New York City Bar opinion says yes, generally, because it's material for the clients to know. You should tell them you're recording. The other thing I've seen a lot is clients recording lawyer communications, and that's one thing very, to be concerned about. Often when clients are upset with their lawyers, they may resort to recording those calls. And so you've got to be careful there that, when you are communicating with people, you need to be careful you're not being recorded on your worst day or when you say your worst thing to the client. That's the type of thing that could really come back and bite you later.
Well, I can speak for those instances where you have someone other than an upset client recording you. And at what stage have we gotten to the point at which lawyers have to ask their clients, are you recording me? I'm not recording you. Or am I recording all and not every, I'm only recording what you say and not what I say. But yes, the lawyers should protect themselves and recognize the quicksand that they're involved with if they're talking to or communicating with a client who's upset, distraught, frustrated with their work, as distinct from frustrated with the litigation that's ongoing, perhaps. But there are clients where their institutional obligation, because they're the second vice president, they have to their direct reports have to communicate accurately what the lawyer said. And you want to make sure that you're delivering the message and being aware that you are being recorded by the client. And because it's not in your office, it's stored by the client, it may be discoverable. So again, lawyers don't have to use the technology that records the communication, but you do have to recognize that clients can be using it because it offers ease or speed to summarize what's communication was going on, but that it's being stored and may not be protected by the privilege that goes along with typical lawyer-client communication.
And I suppose there's instances where most law firms now have policies on what software you can and cannot use, but the clients might not be doing that. And so who knows what they've downloaded or what program they're using, so that when it's recorded, it's not actually even stored by them. It's stored by some who knows what provider and who knows what data room in what country even that could be in. So I guess that poses significant problems as well.
And there are clients of all across the spectrum of financial capabilities who still continue to use software that is for free without looking at the terms of service. And typically free software, those providers, their terms of service say the data that they have is going to be theirs and will be subject to disclosure upon subpoena or even request. So the idea that if someone's going to use software, if someone's going to use an online access means of communication, they should be paying for it so that there is some level or expectation of privacy and doesn't always have to be encrypted, but it does have to have a level of control over the access to it and where it's stored.
And it makes me think, as we're talking more about it, that this might need to be an issue that's addressed at the outset of representation or maybe in the engagement letter, just so you can protect yourself and know that, well, I've let them know that if they decide to go out and get software like this on their own and record conversations, there could be issues. And then also just to let them know about what the issues could be, because it might not be even what they're thinking about. They might not realize that when they record something using AI or some other software, that it's not staying on their phone. It's going into a server somewhere, maybe even in another country, and they just don't even realize that that's going to happen.
There are some talismanic milestones one should recognize when you're a lawyer representing people who may not be sophisticated users of technology, so that you get an email from a client or prospective client who has an email address that's at AOL.com. Do you have an obligation to tell them, geez, that may be an outdated mechanism, and recognize that if I if I have an attachment, it may be stripped away because of the outdated or some less sophisticated use of their email system because it's free and somewhat arcane. Do we have an obligation to do that? And that's what Rule 1.1 seems to invite us to understand, that recognize the benefits and the risk of using particular software. And the standard of care continues to evolve. Now, more frequently, it's changing and evolving more quickly with the development of technology.
If I could, I just want to take a moment to point the camera back at the lawyer. For the last few moments, we were talking about what clients can do wrong, and I think you know how there's an expression. Well, no one will. Some mid-level or senior level manager in a company. Well, nobody's gonna get. I'm not going to get in trouble for hiring blank firm. It's an argument in favor of hiring very large firms, even if smaller firms might do. And on the one hand, technology, the way it allows us in the legal profession, many professions, to leverage ourselves, on the one hand, could spur a lot more single shingle lawyers, or very small firms. But on the other hand, when you mentioned if someone has an AOL email address, I've seen lawyers with AOL Gmail address and Gmail addresses. And so when you're the, what's the expression, cook, chef, and chief bottle washer, when you're doing everything at a very small firm, trying to be an excellent lawyer, you don't have a committee like I think exists in every large firm. I challenge you to show me an AmLaw, pick a number, 200, 300, 400 firm that doesn't have, a committee devoted to figuring out the AI question and what AI vendor to use, and making sure their general counsel, the firm's general counsel, is involved in the vetting process to make sure that the vendor has all the appropriate, security in place. So I just wanted to kind of throw that out there.
Another issue that sort of takes things in a different direction, to go back to Stephen's comments, one of the things that I've seen as sort of a recurring problem is where someone has recorded communications, and often they've recorded communications perhaps between an opposing party and the opposing party's counsel, or they've gotten access to the person's emails or those types of things. And they're delivering what they think is very good information to their lawyer that may, in fact, force their lawyer to withdraw from the case. And one of the things that people, and I say people here because it's not necessarily clients. I had one case where the person who had gathered the information, it was actually a child of the client who shared it with his parents, where he had recorded things because, of course, every 12-year-old now has a recording device in their pocket. But they often don't think about those types of problems. And if the recording itself is made unlawfully, and particularly if that recording also captures privileged information of another party, sharing that information with the lawyer could actually force the lawyer to need to get out of the case. And of course, you're also left in the situation where you can't say to the other side, hey, I wanted to let you know, my client or my client's child or my client's, mother or whomever illegally recorded you, and we've got your privileged communications. But of course, if they send a discovery request saying, please give us copies of all, communications you have involving us, you're going to have to produce those. So this can really create a lot of nightmares for lawyers. And I do think, to go back to an earlier comment, it's good to have conversations up front with your clients so they understand some of the problems, so they understand, what they're doing may impact what the lawyer is able to do.
So keeping us in the scary realm of electronic surveillance, Jonathan, I'll throw this one to you. There have been instances where technology has been used, surveillance technology has been used to prevent lawyers from representing their clients or interfering with lawyers' abilities to represent their clients. And the example I think of is at the Madison Square Garden building. There was surveillance that was used to control who could enter and who could not enter the building. And there was a claim that they were using it to prevent opposing counsel from entering the building as a part of their investigation during a case. What sort of legal implications or ethical implications are there for situations like this?
I remember reading about that it's like a Black Mirror episode, if you're familiar with the TV show. If you're not, Twilight Zone type, think Twilight Zone, but for the 2020s. So yeah, I believe it was Madison Square Garden Entertainment, and it wasn't just Madison Square Garden itself. I think it was also their other venues, like Radio City Music Hall, I believe. And the the reasoning that Madison Square Garden put forth was that it was necessary to protect its employees from, improper disclosure and discovery to prevent attorneys from gathering evidence outside of proper discovery channels. The idea that a lawyer, while at the stadium, might or the facility, might talk to, an employee, and the impact. It has the ability to create direct conflicts with several bedrock principles. Every lawyer has a duty to pursue a matter on behalf of a client despite personal inconvenience and such. And the ban certainly creates a clear, personal inconvenience, maybe arguably intended to deter attorneys from taking cases against the company. The I think MSG was relied on, or at least certainly cited Rule 4.2. Again, that goes to, well, we don't want lawyers, talking with the employee. Who are they going to talk to? The people in the stands giving out popcorn? I don't know. And anyway, I think that Madison Square Garden, didn't it survive a motion? I don't think it lost. Does anyone know? I don't recall. Yeah, okay, I'm getting
I think you're correct. Yes. Yes.
I believe the New York AG has expressed concerns, and it really puts lawyers in a position of, well, I guess I can't go see, can't go to that venue. So yeah, there was a class action, and as I think, and yeah, it was dismissed, and then I think New York, there's a bill or bills that have been introduced to, in response. There's been a legislative response, and I think there have been more lawsuits. So, that's what I've got to say about that.
Stephen, let's talk about something near and dear to every lawyer's heart, and that's payments. One of the great things, just on a practical level, about the advances we've seen in technology and smartphones is the ability to receive and send money very quickly and very easily to, your friends and family members using Venmo or PayPal, and things of that nature, depositing checks using your cell phone, taking a picture. That has been an incredible convenience for people on a day-to-day level, but it presents a significant amount of ethical issues when lawyers are trying to adopt that technology, particularly when it's, maybe solo practitioners or smaller town lawyers who it makes receiving payments and for those types of clients very easy to pay their lawyer, but it creates a lot of problems that most lawyers I don't think are even aware of right now. Can you address those issues?
Sure. The electronic payment, of the electronic transmission of funds, you can't talk about the transmission of payment of fees, for example, without focusing on the larger issue, which is transmission at the lawyer's receipt and then the lawyer's subsequent transmission of those funds someplace else, handling other people's money. And that's governed by the ABA Model Rule 1.15, which isn't exactly verbatim adopted in every state, but by and large, it governs the lawyer's obligation to safeguard funds and property of clients and third parties, so that lawyers are not commingling their money with other people's money. The idea that electronic payments, electronic transmission of funds, clients use it regularly to pay everything. It's gotten so that the The name of the software is now a verb. Venmo the money to me. PayPal the money to Amazon. It is so prolific that it has changed the culture and changed the way we talk. Because clients use it regularly, because of the ease that clients and the speed with which clients can use it, lawyers should be aware of it. There's a recent ethics opinion issued by the state of Maine. I believe it's the bar overseer, so it's not just a bar association, but the regulatory body that had a distinct and an elaborate discussion and places or recognizes that there's two extremes. One, the Venmo, PayPal, and it mentions these vendors by name. Talk about the mechanism by which the money is transferred, both to the lawyer and from the lawyer to others. And there is a layover. There's funds taken from the client or the third party, delivered to the intermediary, and ultimately make their way to the lawyer, and vice versa. If we're talking about delivery if a lawyer is willing to accept payment of a fee that way, in response to an invoice where the money is going directly to the lawyer, intended to be the lawyer's money, the lawyer can make that decision, but recognizing that there are other issues with receiving money that way, particularly the privacy settings on each of those software packages that enable the client to deliver that money. Because in most instances, particularly with Venmo, that's become the most obvious. Anyone can log on to see that my client, Vinnie Jones, is paying me that $5,000 for getting him out from under that problem that no one else knew Mr. Jones had. And therein lies the understanding of the obligation that the lawyer has to give the client guidance to set those privacy settings to prevent others recognizing that the money is being delivered to the lawyer. The ethics opinion from the bar overseers in Maine also described the lawyer-centric software packages that also enable clients and lawyers to deliver and transmit money electronically. There are some products specifically mentioned. I believe they talk about the LawPay organization, the LexCharge, and Clio as being vendors who are sensitive to the privacy issue, the confidentiality issue, and the immediacy obligation that the rules impose upon lawyers, particularly as it relates to money that's coming from others. Lawyers who are holding or receiving money that is not theirs and will not be there. So an escrow fund being held for the closing that's anticipated in 30 days. Those protocols, those software packages are far more compliant and recognized as being more compliant than other types of delivery systems, other types of electronic payment delivery systems. Those are the kinds of things that lawyers need to be sensitive to and recognize so that they can advise their clients whether to use or why we can't use it or why we shouldn't use these software packages that are used in every day, multiple times every day by common users.
And this might not be true for every state, but I know where I practice, the majority of ethics complaints that are received and acted on by the Bar Commission and the state Supreme Court are cases involving attorney trust accounts and commingling of funds. So it's probably a bigger issue than most people realize. And one of the things I think about is when you're using a service like Venmo or something similar, when you receive the payment for somebody, it's not going directly into an account you've designated. The money goes and it sits, and then you have to go in after the transaction's been made and then direct it to where it needs to go. And if you're receiving funds from clients to that Venmo account or related account, it might be all getting commingled in that base account. And then you direct it off into your trust accounts. And I mean, that raises all kinds of issues of, well, what is the status of before you transmit it and direct it to a specific account? what does it mean when that money is just sitting there on that app? It's been commingled. I mean, you've probably violated multiple ethics rules without even realizing it, just because you and I mean, I don't even understand how the technology works or what the agreements are when you sign up for the software. But I think it's an issue that most people don't realize is as risky as it actually is right now.
Isn't there an easy fix to that, though? I agree that I think a lot of lawyers may not recognize it's an issue, but if it's recognized as an issue, can't you just maintain two separate merchant accounts with your credit card processor, one linked to your operating account and one linked to your trust?
And that's precisely what those lawyer-centric software vendors do. They have a separate type of dispute resolution mechanism, which prevents the vendor, like Clio, from clawing back money from your trust account, because there's a separate account through which the funds are transmitted, so that we're not faced with disappearing funds simply because the transmitter of the funds disputes the transmission and tries to have it clawed back from the lawyer's trust account. These ethics problems are the same types of problems that prevented lawyers 15 or 20 years ago from utilizing the standard Visa and MasterCard mechanisms to collect money that would be used for escrow that were intended to be maintained in their trust account.
Although I will say, Tim and Jonathan, your question really raises this as well. One of the really important things to realize is that using all these systems, and my firm uses one of those lawyer pay processing systems and things, you really then have to be paying attention. And lawyers don't like to reconcile their accounts, but it's really critical that you're watching to see, for example, does the client put the deposit in the correct account? Is it in my trust account or my operating account? And also certain payment systems, I know for a while, and I think it's been fixed now, but Square would tell lawyers how much they had received on a given date and how many transactions they had, but it wouldn't tell them how much each person paid them. So, if you realize that on a given day, you could probably be pretty good about saying, how much did I get from Mr. Smith and how much did I get from Ms. Jones? But if you're trying to do this 60 or 90 days down the road, it becomes very hard. And so it's really critical that people are watching money and making sure that things are properly delineated as it comes in.
Which circles back to the observation that Tim was making. It's not necessarily that lawyers don't want to pay attention. It's just that the cumbersome process of keeping track, of documenting it. They're happy to look at their operating account or their trust account to see how much money's in there. Exactly. But it's the idea of keeping accurate and up-to-date, contemporaneously reliable data and recording it so that they can prove that in fact it is reconciled and up to the moment.
Ever since my firm started accepting cryptocurrency, no, I'm kidding. We don't accept crypto.
We could do a whole nother webinar on that.
Absolutely.
Yeah.
Michael, let's talk about a practice specific area. Most lawyers will tell you, especially in the personal injury space, that advances in technology, specifically social media, has been a gold mine, particularly for defense lawyers, because everyone's got a social media account now. And if their lawyer hasn't told them to, hey, we're in a lawsuit, you probably need to put it on private or watch what you post. People are out there posting everything about their daily lives for all the public to see. So we've sort of have left the days of where you would send out a investigator with a camcorder, where now the lawyer themselves can log on to Facebook and see what the opposing party or counsel are saying to the world. So what ethical implications are there now in this world for lawyers who want to surveil their opposing parties?
Sure. So this is another area where, frankly, the jurisdictions really go different directions. And you had commented, tell your clients to put their Facebook page or whatever on private settings. That actually may create an issue with obstructing the other side's access to evidence, but we'll move past that. The biggest thing to realize is that any sort of deceptiveness, getting access to someone's social media or other information is likely to cause problems. The sort of famous examples is, can I look at someone's publicly available Instagram account or Snapchat account or Facebook? And the answer is, well, yes. If the world can see it, you too can see it. What if I need to connect with them or friend them or go through that next stage, become a follower? And that's where it gets really interesting because the first thing is, if I, Michael Downey of Downey Law Group, want to be their follower, first of all, I'm being very open about that, and that may be fine. The question then becomes, okay, what if instead I say, they're never going to say yes to Michael Downey. Maybe I'm going to have someone else. I'm going to have my assistant, Sally Smith, try to contact them. They're not going to recognize Sally. Is that problems? And then what if, in fact, I lie to them? What if I create an account and say, I am now Sally Smith? Well, the interesting thing, the ethics opinions are very clear that where it's public, you're okay. Where you're engaging in active deception, I'm creating an account, I'm not okay. The problem is that area in the middle where you say, well, I'm going to choose someone who can be honest, but I'm choosing them because in being honest, they won't tip off the other side. And so it's there where you see the jurisdiction split. Certainly the safer thing is to say, if I'm making that decision, I need to use someone else. That's a material decision where you're saying, well, the materiality that they're not going to recognize that person is the problem. So I think generally the safer thing for lawyers is to steer clear. And the big thing, I actually, there was a great opinion one time that talked about, if someone walked up to your front door and knocked and you open the door and they said, how many children do you have? Where do they go to school? What hobbies do they participate in? Give me the 50 questions. You'd probably slam the door on them. But so often in the world of social media, we make all that information available and really it's ripe for the taking. So publicly available, generally okay. Not publicly available, you generally need to steer away from it. And the last thing is if you are making that friend request or something, there was a reference earlier to Rule 4.2, which limits the ability of a lawyer to talk with another lawyer's client. That rule also may be implicated if you're trying to have that connection for the purpose of seeing what they're posting. That's likely to be communication that may cause problems under that rule.
And Stephen, I'll direct this one to you. Lawyers are not only out there investigating opposing parties, but prospective jurors. There's a huge industry of doing jury research and taking jury lists and finding out as much as you possibly can about a potential panel that you might have. So what implications are there for investigating jurors?
Picking up on the boundaries that were described by Michael just a moment ago, the boundaries are similarly identified if it's misdirected. Excuse me, if there is some indiscretions and things that aren't public, but you're trying to gain access to juror background, their quotes, the books they like, the political parties they belong to, if that's part of the public record, you can, typically without violating the rules of professional conduct. However, because the circumstance of this investigation involves a court proceeding, the selection of jurors on the presentation of evidence to selected jurors, you have to look at the rules that either the judge has, for example, a standing order, or the court system itself, which may or may not prohibit or restrict lawyers' access to that information. There's a particular case coming from California involving sanctions imposed, a $10,000 sanction imposed on a lawyer and a law firm because of not bad faith or nefarious conduct, but human error. They didn't recognize, or they did recognize, that the judge's standing order said that lawyers cannot use LinkedIn to search and research jurors. Now, LinkedIn is to the extent it's a publicly available, accessible website, that information would be available to the general public. But the judge's standing order said, thou shalt not do that. And the motivation for the judges using that as a standing order was that LinkedIn permits the poster, the juror, him or herself, to be notified when someone looks at their profile. And it's that notification that the judge was trying to prevent, because they didn't want the jurors to feel as if they were being surveilled or accessed through communication. And the lawyer hired an investigator, and the lawyer hired a juror consultant. The juror consultant hired an investigator, and the lawyer never communicated to the investigator that there was a standing order that prohibited access through LinkedIn. But these are examples of the extent to which lawyers need to be sensitive to not only the ethics obligations, but also the standing orders involved with the court proceedings involving the jury selection and the presentation of evidence to the jurors.
I wonder, did the lawyers, consultants, investigator, was his LinkedIn, did he or she have an account with LinkedIn that made it impossible for somebody, yes, people will be notified somebody's viewing me, but I won't know who if the person looking pays the monthly fee. Does that make a difference?
The court's decision didn't distinguish anonymity from visibility. It was the notification that someone is doing it. So going from a profile that has 2 or 3 inquiries per month to 2 or 3 an hour while they're sitting in the jury box waiting to hear the evidence. And it's that notification that the judge was trying to avoid so as not to intimidate or serve as a deterrent for people participating in unobstructed juror fulfilling their obligation as a juror.
So in the time that we have left, Jonathan, I'll direct this to you. Talk to us about probably the biggest hot topic right now, and that has been for the past few months, which is AI. I mean, it is in the news daily. We've already even touched on it in some of the topics we've talked about, but I mean, it touches on almost every ethics issue you can possibly think of. Can you talk to us about some of the big issues that we need to be thinking about? And it might not be just the hallucinated citations and pleadings, but just sort of the major themes that we're seeing right now. Sure.
So I feel like we're sort of circling back towards the beginning of this webinar where we made a comparison of the AI of today versus, using Westlaw or Lexis for legal research at a time when some people were still using books. The model rules, the governance of AI fits pretty neatly into most, of the governing rules in the most basic of ways. Lawyers have to understand the uses and limitations of AI tools if they're going to rely on them for legal answers. That's competence 1.1. A lawyer has to take reasonable care when inputting client data into AI tools. That's Rule 1.6, confidentiality. Obviously, the biggest issue there is making sure that your data stays private and isn't used to train the AI. Supervision, Rule 5.3, every law firm should have in place clear policies that govern how lawyers and other staff are to use or not use AI and what vendors they can use and stuff like that. Yeah, in that respect, I think because there's been so much negative press about AI, there are lawyers who have decided, well, then I'm just not going to use it. I'm not even going to waste my time with it. When really the question should be, okay, let's recognize what can happen if it's misused, but also under the professional rules, we do have a duty to understand it and use it to our client's benefit, because our adversaries are going to be using it. There are even courts now that are adopting it and using it. So to that end, Jonathan, I mean, what are your thoughts on lawyers embracing AI, but also just, being aware of what the risks are? Look, you just said it. We also just circled back to the very beginning of the webinar, 1.1, duty of competence. There's going to come a time, if it hasn't already come, where not using AI is affirmatively, could be problematic. what are my thoughts about it? I embrace it. I embrace it. And I think a lot of law firms had early rules that were just sort of a complete ban on the use of it, which maybe made sense in the very early days, but maybe not. I mean, the concern was the argument's been made, well, let's look at the hallucination issue. Any lawyer that is, I don't want to be too critical, capable, I'll use that word, of using AI and not confirming that the results the results AI is spitting out is not accurate, is also guilty of, would also be capable, I didn't mean to use the word guilty, capable of pulling case law and not key citing it or shepherdizing it. What's the difference really?
I think that's right. And of course, now there are a lot of clients that want their law firms using AI because of the advantages it can give on efficiencies. So, complete bans might be dissuading clients from hiring you.
The standard of care is so evolving so rapidly. 4 years ago, 5 years ago, no one ever heard of a judge saying, well, you have a duty to Google, which has now been repeated often when lawyers are looking at and scrubbing their prospective clients to understand what's going on. The duty to use AI may be the standard in a year, 2 years. At the rapid pace things are moving these days, one really needs to understand the risks, recognize the risk, and if you're going to decide not to use it, there's going to be an economic downside because you'll be not the first choice of a client who actually needs your guidance or advice.
Well, we have reached the end of our hour. Panelists, I'm going to thank you all for your wonderful insights and wonderful discussion. I feel like we could continue talking for another hour probably on these topics. I want to again thank our co-producer, the National Law Review, and remind those who are on this live webinar, watching it live, or those who happen to watch it after it's already been produced. If you have any questions for our panel, you can email those to info@financialpoise.com. Just make sure you include the specific webinar so that we can direct the answer to the right panelist. But I want to thank everybody for joining us and have a great rest of the day.
Thank you very much, Tim.
Thank you.